Dear participants and friends of the Humanitarian Congress in Berlin, it is my great pleasure to welcome you on behalf of the organizers to this next session entitled Young Voices in Humanitarian Law, Paradigm Shifts and Technological Change. I'm Katja Schöberl and very much looking forward to moderating this 1.5 hours that we will be spending together. With me on stage, both physically and virtually, are in the order of their inputs, Dr. Vergerio, independent scholar, online. Dr. Tassilo, lecturer at the University of the Bundeswehr in Munich. Erik Tuchtfeld, research fellow at the Max Planck Institute for Comparative Public Law and International Law. And Mirka Schäfer, head of Advocacy and Mobilisation of SOS Humanity. Let's welcome them with a big round of applause. The session will be live streamed and will also be recorded. We will first hear from the panelists with their inputs and through a series of guided questions, and then we will open up for your questions. You will have the opportunity to raise questions both here in this room as well as online through the chat function. So today, we wish and propose to have a reflection and conversation on paradigm shifts in international humanitarian law, abbreviated as IHL and meaning the laws of armed conflict. A paradigm can be roughly described as a set of patterns, theories, or concepts which shape how we think about the world. A paradigm shift may be understood as a fundamental change in how we perceive and respond to reality. By bringing together a diverse perspective and expertise, we want to explore in this panel how humanitarian law deals with change, technological change specifically, but broader change generally as well, and whether additional transformations or shifts may be necessary to find solutions to the humanitarian challenges that we currently face and will be facing in the future. So let us start the conversation with you, Claire. Can you please describe for us how international humanitarian law has evolved as a body of public international law, and when we have seen paradigm shifts and what they were prompted by in the past?
Sure. Thank you, Katja. Can everyone hear me?
Yes, we hear you well.
Okay, great. Right, so as the resident, I think, history person on the panel, I'm gonna go for the context giving. But I am mindful that I have 5 minutes to answer this question, so I won't go through a century by century development. I think what's really important to know as we start talking about change and international law, and specifically the IHL or the laws of armed conflict or the laws of war, the name has changed over time as well, is that on the one hand, IHL is a very long tradition. It has its roots in some elements of Roman law, some aspects of chivalry from the Middle Ages. There's a whole body of ideas about how conflicts ought to be fought that comes to us from the early modern period. So 1500s, 1600s, 1700s. Many of you may be familiar with the names of Hugo Grotius or Alberico Gentili, but really what's most important to understand kind of how international humanitarian law has evolved as a body of public international law, the most important element is really the late 19th century, because that's when international law emerges as a discipline, and it is at the heart of this new discipline, the main pillar is the laws of war. So to understand where international humanitarian law comes from, we really have to look at the period during which it's codified, the first time it's written down from the roughly 1860s onwards, just about 150 years ago, which in historical terms is really quite recent. And over this period, we've seen a fair amount of evolution of IHL, but in many ways it has also remained quite true to the way it looked when it was first written down. So, of course, and we'll talk about this to some extent today, we've seen a lot of developments because of technological change. That's often the main driver of why the laws of armed conflict emerge, or rather why they change. So a few examples: expanding bullets. These were particularly deadly kinds of bullets that emerged in the late 19th century that were used quite a bit in colonial warfare, notably, that were outlawed. We then saw the development of submarines that required developments in the way conflicts were regulated. Nuclear weapons is another one. I know we'll talk about AI today. But something I'd like to submit for the purpose of this discussion is that regulations that aim to address technological change don't necessarily constitute paradigm shifts in terms of IHL, in the sense that they are changes in the rules, but they don't fundamentally, at least in my opinion, transform the way the rules apply and the broader system of rules. And I'm looking forward to potentially disagreeing with some colleagues about this. So to give you a sense of what I think is a much more meaningful paradigm shift that has happened historically, there is a moment at which we decided, and I would submit that this happens in the late 19th century, that only sovereign states have the right to wage war, and that as a consequence, only actors who are fighting directly on behalf of a state have the right to kill. This also means that only states have the right to self-defense. This wasn't always the case historically, and it meant eventually that, for instance, during colonial warfare, all national liberation movements who weren't fighting for states, because by definition they weren't states, were considered to not have the right to use force, and therefore they were considered to be terrorists. In my opinion, that's a paradigm shift, deciding that we're going to move from a world where lots of different actors have the right to wage war to one where only sovereign states have the right to wage war, and that this is going to be the basis for how IHL operates. That is a fundamental change in how we regulate conflict. So we'll see what that means and whether we can tie that to the debates about what diversity means today, what we need, as well as we think about how international humanitarian law could be more just for the future. But one thing that I would like to also submit as the sort of little historical perspective that I think is useful for this panel is that often we think that paradigm shifts have happened in international humanitarian law because the goal was to make war less inhumane and less brutal. And something that I think history shows us is actually that a lot of this has to do primarily with power politics and with the attempt of those who are already powerful to further assert their power and their dominance. So hopefully that gives a little bit of context about where international humanitarian law, comes from, what a paradigm shift might or might not look like, depending on how you think about it, and what might drive some of these shifts over time.
Thank you very much. And we will be looking at the issue of technological change in more detail with the next panelists. But for now, Claire, you shared your reflections on what effects diversity could mean in our legal and humanitarian discourse and effects that it might have on paradigm shifts in law. So in your observation, also from a historical and long-term perspective, is there a shift towards a more social and just legal system? And if not, what kind of shifts would be necessary for the system to be more appropriate to deal with the challenges that we see?
Right. So, I think there's been a little bit of a shift. I think we can think a lot bigger in many respects. And I hope that those who are here today are hoping to think big as well, because we clearly need new solutions in terms of how we regulate conflict, because whatever we're doing now, it seems to be a very disappointing approach overall if we look at the amount of absolutely brutal violence going on in the world at the moment. I think diversity is a huge asset in making these rules, and something that's really important to remember historically is that when the rules were first codified in the late 19th century, this was a remarkably not diverse moment. This is probably the moment when the West was most exclusive in how it decided to make the rules. So it was mostly Western countries with a few select invites, notably to recently decolonized Latin American states, to make the rules together without really including the voices of anyone else. And what's really problematic about HL today is that in many respects, that is the system we inherited. That is the way of thinking about how to regulate conflict that we have inherited. So there were, of course, a lot of efforts to change those rules, especially during that moment of activism and decolonization in the 1960s and the 1970s. That saw a huge push to rethink things like the international economic system, but also things like the way we regulate international conflict. One really important aspect was the push to give national liberation movements the right to use force. That was a semi-successful attempt, but that was a real paradigm shift in the sense that it really sought to profoundly change the rules of how conflicts are regulated. I think we're not seeing anything quite as ambitious today, and I think that is a real problem. If you think about, for example, the way we talk about who has the right to self-defense in any sort of armed conflict. If you are the people of Ukraine, obviously you do, because you are fighting on behalf of a state. If you're an indigenous group under violent assault by a state, you don't have this right because you're not a state, at least not as a collective body. So this is something which I think really needs to be on the table in terms of the discussions that we have. Is this just? Is this fair? Do the laws of war really reflect a just system that we can stand by today, or are there elements of it that we inherited from that late 19th century non-diverse moment that we maybe want to rethink at this point? And so in this sense, I think there are many, many shifts that are necessary in terms of those rules. I'm sure we'll talk a lot about some of the technological ones that have to do with, for instance, the emergence of AI. And I think that's a really important aspect of the discussion right now, because obviously we have to deal with AI and what it's doing to armed conflict. And international humanitarian law is always behind technological change and trying to adapt to it as we move forward. But I think it is also time maybe for a more fundamental look at the values and assumptions that underpin the system more broadly in terms of some of the basic ideas of who should be allowed to use force in the first place and why, and what types of exceptions we make, and do they make any sense? Are they fair, or are they just inherited from 3 generations ago in a context that was completely different and that we would no longer deem appropriate today? So I hope that we can have a conversation both about technological challenges today and how to face those as lawyers, as scholars of today and of tomorrow, because I imagine there are many of them in the room, but also perhaps we can have a broader discussion about what it means to regulate conflict fairly in the contemporary world. Thank you.
No, thank you very much, Claire, for setting out the different issues so clearly. For us as we embark on this conversation. We will, for now, be changing to the issue of technological change more specifically, but then come back to the broader issues in the discussion later. So, Tassilo, turning to you, could you set out for us how technological change impacts paradigm shifts in IHL, and maybe share a bit your reflection on what kinds of technological change have led to or are leading to what types of paradigm shifts?
Thank you. Thank you first for having me here. Well, according to my opinion, we have to start a little bit before IHL, and just to set the frame for technological change, we have to remind ourselves that international treaties, in particularly IHL, is based on the principle of reciprocity. That means that states who want to be bound by this rule or this treaty have to agree on it. So that's what we are having at the moment with the Geneva Conventions from '49 and the additional Protocol 1 is the outcome of an agreement of states. And you can look it up to the treaty parties, to the Geneva Conventions, for example, that these are mostly all of the states of the world. Additional Protocol 1 is a different story, but basically this is the framework. And in Additional Protocol 1, there's one rule which is very pivotal and very central for technological change, and this is Article 36, which means like weapons review. And this means independently of the technology, that all weapons which are meant to be used in the conduct of hostilities and in an armed conflict, they have to be tested according to some sort of procedure, just as a general rule. And this rule basically is also the connection point for, or the answer basically to the questions, how is IHL responding to technological change? IHL, is the answer, is flexible. It is shown in this particular rule. And this rule is cited by the International Court of Justice in its nuclear weapons judgment when they had to discuss about a pivotal change, a paradigm shift in warfare, like how are we acting, how is the use of nuclear weapons to be considered under IHL, under international humanitarian law. I know the outcome of the judgment is fairly controversial and it's still part of a lot of discussions about technology. But my answer first is like IHL in general is open to new technologies. However, it has to be interpreted in some sort of way. A second point of this frame is, as I said, we have the reciprocity principle, and we cannot, unilaterally make up rules and bind any other sovereign states or any other non-state armed actor to these rules. In times where we have geopolitical tensions, as now, so where we have big fronts between the West and the East and the South and the North and so on, it is very hard to get new rules to be agreed on and new treaties to be agreed on. And so the only chance for IHL to be effective at the moment, as we won't get new treaties, is that we have to adapt the interpretation and find common interpretations of rules and stress the existing rules and the binding to existing rules. So, coming back to your question, how does law react? Well, the law has options for it, and at the moment, as we don't get new treaties, and we did get the last technological treaties on IHL, I think 10 years ago or something, or 8 years ago with this cluster ammunition treaties under the UNCCW, but other options are not available at the moment.
So what would you say, how should IHL and the IHL lawyers then respond to these shifts through interpretation? Is that what you're saying?
I want to get one step back. Well, if I have to make one or two examples just to stress the technological perspective. We have new technologies that have to be looked up now, and I will make a big step back and say, like, well, the internet, the sharing of information has changed also the conduct of hostilities fundamentally, because informations are available by everyone. The governmental control is very, very restricted or not possible via VPN or something like this. And so this has implications on the battlefield and the conduct of hostilities. A second, really, I think, technological change is also the use of social media, which even more increases the sharing of information, but which can have very grave consequences for IHL or for the parties be obliged to IHL, or for, well, I would say, people who have nothing to do with a conflict but get drawn into it because they just share information via social media. Just to give an example, if you look at a big conflict in the East at the moment, people like civilians were called by the government to share photos of enemy forces via social media or share it to their military centers. This could be interpreted by the other party of the conflict as a participation in hostilities and therefore render civilians a legitimate target according to IHL, according to Article 51, Article 3, and Paragraph 3. And same applies also for example, for the work of humanitarian aid. If they want to share information to get a public awareness, to be transparent, to show that there is a grave evil or something happening in the area, this could render them a certain subject and party to the conflict, or at least inflict their position with view to the different fighting forces, which at the end could lead to them being a target or them being picked out and not let into certain conflict areas because they just shared information with these new technologies. So I think this is something really that has to be adapted. So coming back to how do the lawyers have to react, I think I answered it partly with my input before. Well, you have to be very quick on the technology, you have to be very aware and flexible and have to think about like the general principles of IHL, about the balance between humanity and military advantage, about the qualification of subjects, about the speed of time. Just one last example, if I may. If you look at Article 57, AP1, Additional Protocol 1, you have the rule that when you have started a targeting process and send a weapon free, for example, or start to send a weapon free, you have to always watch the target and see if there are changes in the area. So if you have a change of information, which you get by new technologies, you know, the time frame is much shorter and you have to react on some sort if you at some point can do it. So also this means new technology can also impose new obligations out of existing rules on the parties to the conflict. So yeah, that's my answer.
So the big question before we move on, it really has to do then with artificial intelligence, right? And so the question being, is this a shift or is this really an end of paradigm in the rules of international humanitarian law? How can or how should IHL be integrated into autonomous weapon systems or military decision-making more broadly? Is it compatible with the way how we think about armed conflicts and their legal regulation?
Well, that's a very difficult question, and I could talk for hours about it, but I try to make it very, very short. First of all, artificial intelligence, as any other technology, just speaking broadly, is subject to Article 36, Additional Protocol 1. So if any party wants to include artificial intelligence in its weapon technologies, there has to be some sort of weapons review, which will then, in the best case, you know, look at the ability to still comply to the obligations, be compliant to the obligations. If you look at military decision-making and AI, we have to be very careful about our understanding of AI. There is no one AI. There are artificial intelligence functions. So there can be an artificial intelligence object recognition. There can be an artificial intelligent information data fusion system. There can be an artificial intelligence target evaluation mechanism, which just does numbers. And there can be an artificial intelligence mechanism that even, and this is kind of the really, really hard part from perspective of IHL, could select targets and engage targets. There could be, you know. And if you look at specific cases, basically, you have to look that if the artificial intelligence function is planned to be included in the process of targeting, you have to look if this inclusion complies with IHL, meaning to have some sort of human control, meaning to establish a responsibility like you have with the rule of commander's responsibility, and so on and so forth. And therefore, you have to then check this specific artificial intelligence functions with its compliance with IHL in the whole process. But that means you really have to go to your targeting processes and have to look it up and have to check, is this equivalent to general human behavior and so on and so forth, and this is very difficult.
And we won't go into much more detail on this very specific question, but just to mention, I mean, the regulation of means and methods of warfare is one big part of international humanitarian law and addresses precisely those types of questions that Tassilo is raising. But another one, of course, is the protection of those not participating in the fight, right? So including their access to humanitarian assistance during armed conflicts. And that's something that we want to look at now with our next speaker, Erik, and raise the question with you of how accountability, do no harm principles be included into AI-based humanitarian action, and how we deal with data collection, analysis, prediction of needs, and all these sorts of issues in humanitarian aid based on international humanitarian law.
Yeah, thanks a lot for the question. I think it shows already from the question that it's quite a range of topics, and Tassilo mentioned already that there is not one AI. It's a big term for many very different, actually even technologies which are somehow collected under this term. And I think it really matters to take a look at particular functions which AI fulfills, and then try to evaluate the harm it might which might occur. So I think that which is kind of obvious, the do no harm principle is maybe the most important principle of humanitarian aid. The very idea of not that the support conducted by humanitarian organizations should not unfold negative effects on the population. And I think when deploying, like very broadly saying, any kind of AI technology, it's important to keep in mind that the output of such an AI system can only be as good as the input. So data collection is very important. And when it comes to the input of the data, we can also differentiate between the training data, so the data which was used to train the AI system, which was used to create the AI system, and the very concrete input data given to the AI system to then make a decision or give a recommendation or some kind of prediction or something like that, depending on the particular application. And it's important to be aware that AI is not some kind of magic and you have a problem and then you execute some kind of AI application and then you get a solution for it, but that the AI system can only be as good as the input. If there's bad input, if you don't have information, then you will have an output which is probably bad and which at least has to be considered with a grain of salt. The next step, in particular when we come to the quality of the data, is that there is no such thing as neutral training data. So in many AI systems have some kind of biases included in their application. And when we look at concrete examples, for example, the use of AI systems for authentication and identification to, for example, hand out basic supplies like food and other health supplies and something similar. So in some refugee camps, AI mechanisms, AI applications are used for the identification of people to then hand out these supplies. If they are not identified, these supplies are not handed out. But we know that some of these identification systems work way worse for people with, for example, darker skin color. And if the deployment of such a system, which should help and facilitate the process, make it smoother, make it easier to access the supply, then leads to a situation where people which have a right to access some kind of supplies cannot access it anymore. It's kind of a serious risk by these technologies, And the third and maybe most important point is the question of privacy. As I said, AI systems can only be as good as their data input, so they need information. But at the same time, collecting information on a big scale always poses a lot of risk because it contains lots of information, the very thing it should do, about people, and some of these information are quite sensitive. When we start collecting information in big databases, there's always the risk that these information at some point will also be used by other entities. So the idea of data minimization, to only collect the information which are absolutely necessary, is, I think, absolute key to at least reduce the risk of harm when deploying these kind of new technologies.
Thank you. And since you mentioned the importance of data input and the quality of data, the question comes up what human rights law in IHL in armed conflict situations has to say about surveying the digital and analog environment. How can AI be used and should it be used? Can it be used based on these legal paradigms? What are your thoughts on this?
Yeah, I mean, when it comes to the use of AI, some call it simply a surveillance instrument. On the one hand, because you need to have lots of data, as I said, to train these systems, and in many cases, this also means lots of personal data. So you need already to have a system of surveillance, of collecting personal data on grand scale, to train these kind of systems, to make them even like existing. And then to use them, you still need to have the data you need to have information about the scenarios, so you can then use the AI, for example, for predictions, or also for, I mean, when it comes to military decision making, for very personal information about people, which then calculate some probability if this person is a legitimate target or not under AHL. But of course, even in situations like occupations, but also, I mean, in situations where humanitarian aid is deployed, for example, refugee camps, these people, they still have human rights, and this contains also the right to privacy. So there is a general right to have privacy, to have private communication, to not be surveilled under any circumstances, and it changes the situation, the life of people if they are surveilled or not. We know it, I mean, it's really like common sense. We know it in places like Germany in peaceful situations, but we also know it in situations of conflict, that people change their behavior, and the people change their behavior when they are under surveillance, and this has adversarial effects on many other human rights, because privacy is some kind of a precondition for the exercise of many other rights, when it comes, for example, to the freedom of expression, when it comes to the freedom to assembly, the freedom to hold an opinion. Once you feel that there is surveillance, that you cannot hold your own thought anymore without powerful entities knowing what you think of such stuff, and possibly punishing you, this really has very negative effects on human rights.
I mean, one aspect surely is privacy issues, and the other one then has to do with the regulation of information through content moderation. So, in your understanding, what is the significance of content moderation for IHL compliance? When we talk about armed conflict situations, what role do misinformation, disinformation, but also the existence of information play in our perception and then in the acceptance of the IHL rules which govern those situations?
Yeah, I think that's very interesting, because there are three dimensions. One is the one Tassilo already talked about, that social media enables basically everyone to share information. And it also enables people living in situations of conflict to share information. And sometimes these information sharing, when it concerns, for example, the position of military material, might change their status under international humanitarian law. But at the same time, it's also used to document, for example, violations of international humanitarian law. So we know that open source intelligence is very important when it comes to raising awareness of violations of international humanitarian law, and also to later collect evidence, for example, also for the persecution under international criminal law for those who have perpetrated crimes, for example, crimes of war. So we have the importance of information sharing and collection of information on social media. The moderation, the content moderation exercised by platforms has, for example, led in the past to a situation where evidence for war crimes have been deleted because it violates their terms of services. We can see how some big companies in the Silicon Valley then establish rules and exercise them, and the setup of these rules and the enforcement of these particular rules then leads to consequences in armed conflicts in other places of the world. Also, we have seen that content moderation, if it's applied in a bad way, or if there's, for example, content moderation not exercised at all because, for example, of language barriers, because the big social media companies are still mainly conducting their content moderation in the big, mainly Western languages, then it can even lead to civil conflicts. It can even lead to situations like genocide, because also historically media was always important to spread propaganda, to spread hate, and also to spread disinformation about particular groups, marginalized groups, which have then been persecuted in situations like in situations which at least come close to genocides. So we have the sharing of information. We have content moderation, which, when there is no content moderation, can also steer conflicts. And we have also some kind of meta level that the discussion about law is also taking place on social platforms. So many experts scholars of international humanitarian law, but also states, I mean, there's some kind of even diplomacy now going on Twitter when you follow the accounts of official accounts of embassies and foreign offices. This all happens on social media, and we I think the way international humanitarian law is discussed on social media also changes our perception of it. More people are informed in a really concise manner by very established scholars about what a particular rule of international humanitarian law means, how it applies to a very concrete, specific situation of conflict, which might be discussed in the newspapers at this current situation in time. But at the same time, we obviously also have a lot of misinformation. A misinformation when it comes to the legal interpretation of rules. So some people are trying to push forward interpretation of rules which are simply not shared by anyone in the legal community, but it's often difficult for people who are not trained as lawyers to then evaluate the quality of such an interpretation. And at the same time, obviously it's also even more established rules which are challenged then in public discourse. It's not only anymore a discourse on panels like this one, on conferences like this one, and in the journals and in court decisions, but it has become a public discourse on specific rules of international humanitarian law, and of course this also changes these rules and possible interpretations of them.
Thank you. I'm assuming we might come back to some of those aspects in the discussion later, but we've now arrived in the middle of our reflections around the role of facts and law. And this leads us, Mirka, to you. And we want to broaden our perspective now a little bit from the international humanitarian law, the laws of armed conflict, and also talk about international human rights law and refugee law, and ask you what your perception is of what the role of facts and the law in the current migration discourse is. How are those bodies of law currently being perceived and talked about in your experience?
Thank you. I'm happy to bring in some operational examples and challenges from the side of SOS Humanity. The current migration discourse is dominated by a framing of migration as a threat. Migration is not acknowledged as a human phenomenon that has always existed and will always exist. The narrative in the EU is that there are too many refugees and that Europe can't handle it. But it is not a question of numbers, it's a question of political will and of commitment to human rights. The EU has managed to welcome 4.2 million refugees from Ukraine as of November 2023. The EU was very quick to activate the temporary protection mechanism, which includes the access for Ukrainian refugees to the labor market, housing, to move freely within the EU, medical assistance, and so on. However, for people fleeing from other countries, the human right to asylum is increasingly restricted in the EU. The possibility of obtaining asylum in the EU presupposes that a person makes it into the territory, or at least until the border of the EU. At the same time, the access to this territory is systematically restricted. This asylum paradox leads to a serious human rights problem and to violence and death at Europe's external borders. EU migration policies of deterrence and of closed doors are responsible for the humanitarian crisis that we are witnessing since a decade in the Central Mediterranean Sea. Since 2014, more than 30,500 people have died in the Central Mediterranean Sea. On average, 4 people drown every day this year. The migration route remains one of the deadliest in the world. SOS Humanity is one of the organizations, a humanitarian search and rescue organization, trying to fill the rescue gap that states have left behind. The Italian maritime rescue operation Mare Nostrum was the last one that deployed rescue ships in the Central Mediterranean Sea. It was followed by a European military operation, Sophia, but as of now there are no more rescue ships from European member states active in the Central Mediterranean Sea. However, there is a system of surveillance technology also. For example, Frontex airplanes and drones are monitoring the situation in the Mediterranean Sea. This does not lead, however, to more rescues, but to more interceptions and forced by interceptions and returns to Libya and Tunisia. The Central Mediterranean Sea is not a lawless space. Our humanitarian work there is based on a comprehensive legal framework. The international maritime law sets as rules to ensure that every person in distress at sea receives timely assistance. It is crucial for protecting the right to life to follow these rules. The duty to rescue applies to all ships and all assets at sea equally. Coastal states must ensure that every person in distress receives assistance, and a rescue operation ends when the persons disembark in a place of safety. International human rights law under international human rights law, it is guaranteed that in the non-refoulement principle that no person should be returned to any place where there would be facing torture or other ill and inhuman treatment or degrading or irreparable harm. However, the daily reality in the Central Mediterranean Sea is that these legal obligations are violated by state actors on a daily basis. Distress calls remain unanswered, and information about boats in distress is not shared, even though Frontex is using this surveillance technology and is live streaming what is happening and with the boats at sea to the Frontex headquarters. I want to bring one example of a rescue operation of Humanitarian that happened in March this year. Humanitarian was assisting 3 boats in distress that were unseaworthy, overcrowded, the people had no life-saving equipment, and there were approximately 100 people. While Humanitarian, our rescue ship, was conducting the rescue operation, the so-called Libyan Coast Guard arrived and violently interrupted this rescue operation, and people went overboard. They fell and jumped into the water because the so-called Libyan Coast Guard officers were threatening with gun. They shot into the water where people were and next to our crew, and our crew had to retreat from the scene and only was able to take 77 people with them. The rest of the people, an unknown number, was left in the water and taken back to Libya. According to one of the survivors on board Humanitarian, at least 1 person drowned during this incident. The patrol vessel that interrupted the rescue operation was donated and by Italy and funded by the European Union. More than 80,600 people have been returned to Libya in violation of international law this year alone. Many people tried to flee several times from this country, such as a 20-year-old survivor from Sudan who was on board Humanitarian, and he was rescued last year in August. I would like to share his testimony with you. I am a refugee. All refugees have a story. The children of my country, they lost many things: their future, their education, their health, and their parents. In my city, there was war and destruction around me. I left my country and came to Libya. I thought that my life would be better in Libya, but the contrary was the case. There's racism against all black people in Libya. There's no freedom in Libya. I was asking for asylum and protection at UNHCR in Libya, but they never answered me back. I tried to cross the Mediterranean. The first time I was not successful. The second time neither. I became one of the prisoners of Libya. You have to pay a lot to get out of the prison. I heard there are human rights in Europe and said to myself, I have to go there. So I tried to go on a boat another time. If there had been not the rescue ship of SOS Humanity, I would either be dead or in prison. We lost a lot of friends and brothers to the sea. The migration of the Mediterranean is a problem and a catastrophe because the European Union is financing Libyan authorities. The authorities use terrorism against the refugees. They are not a government. They do human trafficking. They hand the migrants from person to person, from employee to employee. The payment to Libya and Tunisia is used in a bad way. Europe should stop the support of militias. His report is not a singular case. We treat people with signs of torture on board Humanity 1 every time we after conducting a rescue operation, and people report being detained in Libya and that they tried to escape. This is also what the UN fact-finding mission found in Libya. They even said it amounts to crimes against humanity that were committed against migrants and refugees in Libya. Nevertheless, the EU is continuing this kind of cooperation, not only with Libya, but also with Tunisia, despite human rights violations against migrants and refugees in Tunisia as well. Instead of the continuous disregard and the erosion of international law in the Central Mediterranean, we urgently call for compliance with applicable law and legal norms.
Thank you very much, Mirka, for this report and your analysis of gaps in regulation and compliance. A follow-up question relates to the role that civil society organization like yours, but also young people broadly, which is also a focus of this panel, can play in advocating for compliance of existing norms, but also advocating for shifts in regulation, creation of new norms, if necessary. Is that something that you can also talk about?
So SOS Humanity was founded in 2015 by engaged members of civil society who are committed to human rights, and people from all over the world join SOS Humanity and other humanitarian search and rescue organizations to take action in light of the rising death tolls at Europe's borders. The average age of SOS Humanity, within SOS Humanity, is quite young. There are many people in their 20s and 30s, such as myself, and they come from very diverse backgrounds. So, for example, we have volunteer groups in Germany who raise public awareness and who also raise funds. And on board our ship, Humanity 1, there are 29 crew members who come, for example, on board as seafarers, as cooks, medical staff, protection specialists, mental health specialists, and also as media professionals. And together as humanitarians and as civil society, we stand up for human rights. That's even more necessary because we face increasingly shrinking humanitarian space in the Central Mediterranean Sea. We see new and continuing attempts to defame our life-saving work, also by the use of fake news and social media, and to obstruct and restrict it through laws and administrative practices. Since 2023, humanitarian rescue ships have been detained in Italy on the basis of an Italian law in 26 cases. This has led to a loss of operational time at sea for more than 500 days. We have taken legal action against unjust obstruction of our life-saving work, and in Italy, both in Italy, and we have also filed an official complaint to the European Commission as guardian of the treaties. One time, Humanity 1 has been detained in Italy, and this was following the incident that I described in March with a violent interference of the so-called Libyan Coast Guard. Afterwards, Humanity 1 has been detained in Crotone in Italy for 20 days. And we appealed against this detention. And in June this year, the Civil Court of Crotone ruled that this detention was unlawful, in fact. The court also established that the so-called Libyan Coast Guard and the Libyan Rescue Coordination Center are not legitimate search and rescue actors because they cannot provide a place of safety. However, these types of appeals and also litigation take time and resources, and it's not always possible, especially in time-sensitive matters when there are persons at immediate risk of drowning, or also when there is the immediate risk of an interception and violation of the non-refoulement principle. A big question for us is how can we hold states accountable? And this is also maybe a question for us here.
Yes, and before we open up the discussion, I saw that Erik, you wanted to react to Mirka's last point.
Yeah, not a last point, but a point you made before. I wanted to emphasize that and to stress that, because you talked about border technology and how we can see mass surveillance, for the example, in the Mediterranean Sea. And I think it's something we can see also on a broader scale, that also in the field of humanitarian aid, but also when it comes to border protection, the technologies are used which are still kind of experimental. So technologies which are not deployed within countries, in particular not within northern Western countries, because there's a strong objection by civil rights actors, because there's a strong urge to protect fundamental rights, are then deployed in other scenarios where the citizens of those governments who deploy these technologies are not observing the situation as closely. For example, when it comes to quite massive border surveillance, or the use of biometric identification in refugee camps. These kind of technologies are never used in kind of civil, peaceful contexts, but only in these kind of very particular situations. And I think they are often also deployed with a lot of goodwill. I mean, not so much when we talk about border surveillance, but when we talk about the use of other AI technologies, in particular in humanitarian aid, that there is this wish to deploy technologies which are as helpful as possible, then as quickly as possible, by a sense of urgency, because there's a conflict, there's maybe also massive violence spreading, but often without assessing the real consequences such technologies can unfold in a middle or long-term perspective.
Thank you. Thank you all very much for your contributions so far. Now is a good time to open up this conversation for the audience, for you. So I recall that it's possible to ask questions both here in the room as well as online through the chat. And we do appreciate it if you share your name and your affiliation, if any, at the beginning of your question. And let us know who the question is directed to. That also helps. Thank you.
Hi, my name is Diva. I'm part of the Network on Humanitarian Action. I'm studying there. So my question is to Dr. Tassilo Singer. You said that you think that the shift that we need in IHL is more towards interpreting the text, interpreting the law. Do you think that's enough? Because right now, I feel like we're dealing with so much non-compliance of IHL and non-compliance to human rights as well. Do you think that agreeing on interpreting the text is enough? Because state actors, I feel, don't respect even the current laws and interpretations that we face right now. So I just want your opinion on that. Thank you.
So, you're asking for my opinion. The problem is that if an actor does not want to comply with an obligation, it is very hard to force him to it, in particular to force states and to entail some sort of responsibility. I mean, there are responsibility mechanisms in the ICT, in the ICCs or the International Criminal Court and so on, but still this instrument yet is not accepted by all states and also the important states. So you have kind of, if you have a rule that is not followed, it is very hard to enforce it, because what other exception or what else do you want to do? You cannot make a well, you can question the states by itself, their own existence, but then you will have other critical choices to make about rule behavior and so on. So basically what I wanted to say is, if we have only the agreement of everyone to oblige to a certain rule, we can only enforce this one. And if we do not get any new rules, even if they might be necessary, we do not have another choice until states start to agree again on certain rules. I want to give a different example. If you look at the former Iranian nuclear agreement, this was a very, very hard agreement phase, and it took years to reach this agreement, which then after some years got stopped again because of political tensions. But this shows that you can achieve certain obligations, and well, not only interpretation, of course. Interpretation is for the users, if I may say so, the users of the obligations, the people who are obliged by it. But what can civil society, what can politics can do about it? Of course, they can demand that the rules are getting changed. They can demand that we need a new treaty and so on. And that is also something that can society do. But from the perspective of the governments, of the parties that are bound by the treaty, I just try to be very realistic, even if the outcome is not very positive, you know. But you know, that it is also something, it's a mechanism in international law, in particular if you consider the use of weapons or the development of weapons. Look at the UNCCW process with lethal autonomous weapon systems. This process is going on since, I think now, 12 years or something like this. And the foremost outcome is that the parties are now discussing about a definition, you know. So there's no obligation inside. And so this seems to me that the parties that are involved there, and I mean, these are, every state basically is giving up their opinion, that they decided that they are not yet ready for an agreement, because if they would have they want to use this technology somehow, and you can see it in our recent conflicts that parties do not want to restrict themselves in the usage of weapon technology. And so I think, you know, what I wanted to say is the problem lies deeper.
Hello, my name is Hiram. I'm working with Diakony. My question, I don't know whether it's to the entire panelists, but around IHL and the adoption of technology, to my understanding, the IHL is more framed in text, very specifically to states, combatants, civilians, humanitarian actors, you know. But today we see the armed conflict situation has been a space that is now engaging or other actors. And I think one of the panelists mentioned the private companies, the technology companies, individuals are in one way or another either facilitating or directly or indirectly engaging in armed conflict. Do you see that this is the direction where the paradigm shift on the IHL ought to expand towards, to have or to explicitly reflect the broadened space that was possibly or not, in the reality was not the context under which IHL was framed originally? And my second question to Mirka is, you've mentioned that the state authorities, the Libyan Coast Guards and the Italian surveillance, and I worked in Libya, and I really acknowledge and recognize what you explained is a reality, that the migrants or the people who are intercepted are taken back, and instead of safety they are taken to detention and all that. And this application of technology in surveillance, do the humanitarian actors need to also apply the same in terms of identify the needs, surveilling, but now in the positive way to identify who is in distress, who needs assistance, as much as the other side or the actors are using technology in not very protective objectives. Thank you.
Just to react to the first question, I absolutely agree that the borders and the lines and the precise differentiation between actors is getting more and more blurred as more and more big technology companies are getting involved. Just consider Starlink, for example, just consider like social media, big social media companies and so on. And well, just to make a really bad example, but consider that, I don't know, Facebook or someone has a data center in Ukraine, and information on the conflict are shared via social media, via their Facebook mechanisms, and that could render the data center as a military target because it is used for sharing information that are militarily advantageous or relevant to the other side of the conflict. So I absolutely agree that these new technologies and their, well, separation and also their linkage to more, I think, dual-use character, civilian purposes or not, makes it very hard from an IHL perspective to keep up the originally meant distinction. So this is definitely a very relevant factor. And so thank you for pointing it out.
And Claire has raised her virtual finger, so we'll go to her. And maybe, Claire, if I can also add on to it, would we be going full circle if we broadened the addressees of IHL again and included private companies? And is that, I mean, what does history tell us about that?
Yes, exactly. So I think this is a really great question. How do we think about the role of private companies, private individuals in IHL today? And I think this is where having a bit of historical perspective is really important, because I hear so many people saying, you know, the problem is that IHL just didn't think about those ways of fighting war. It didn't realize that there would be all these private companies and all these mercenaries. And that's precisely the opposite. The first element of codification you get in the late 19th century is in 1856, with the abolition of privateering, which are basically mercenaries at sea. So what happened with the codification of IHL was precisely in a context where there were many private actors who were still using force, especially mercenaries and privateers. There was a sense that what the law needed to do was to be just about interstate conflict fought by state armies. So the rules at that point turn all these private actors into actors who are not going to fall under the protection of the laws of war. And that is very much the intent at that point. So what's happening today is that we see a resurgence of these kinds of actors. The problem is not that IHL never thought these actors could be fighting in armed conflicts. The problem is that IHL explicitly excluded them from the ambit of the law in the first place. And now we're very much stuck with that problem. Because ultimately, when IHL first developed in the late 19th century, when it's codified in its current form, the idea is that it's only going to apply to conflicts between states. And that was a very specific decision, which was relevant to some extent for some of the main conflicts of the 20th century. But the main conflicts of the 20th century were very much an exception in terms of how violence has unfolded internationally over the past few centuries. And what we're seeing now, to some extent, is a return to normal, with IHL being extremely disappointing in its ability to actually deal with normal forms of violence within the longue durée version of the international system. So perhaps that's helpful a little bit for some context as well.
One more nuance. I just think that it might help to also look at other legal regimes, because this discussion about the legal obligations of private entities for a legal framework which was originally directed against the state is something we also have very strongly in international human rights law, because also human rights law was mainly directed at the state, but now we have these very powerful private actors, and what do we do with them when they interfere with human rights? And I mean, we can at least tell that the debate of the last 20 years bear some fruits. So there are corporate human rights principles which many of at least the big players, at least in the field of technology, are somehow voluntarily obliging themselves to. I'm not the biggest fan of these kind of more or less legal documents. It's very debatable what the legal nature is, but it at least shows that the attention on the topic and the public discussion and public pressure can improve the situation to some extent and can lead to a situation where the technology companies are held accountable to some extent by public opinion, basically.
Thank you for the question. It's a very important and relevant one, because one of the biggest operational challenges for humanitarian assistance at sea is how do we know where people are in distress? So it's like a search for a needle in a haystack, you can say. And yeah, the question if the application of technology could help to find the boats in distress is therefore very relevant. However, there is the legal obligation for coastal states to coordinate search and rescue. So as soon as they are aware of a distress case, they must inform assets that are nearby and instruct them to search and rescue the boat in distress. So we are advocating for a change of the reaction of rescue coordination centers, and they use the surveillance data from Frontex, and they are aware about distress cases. So this is where we have to push the states actually to act in compliance with international law. However, in the meantime, we are also, there are projects that are developing also new technologies with the use of drones. They are working on this with the idea to how can we ensure that people in distress at sea are being rescued. Also on board Humanity-1, we have been using, for example, we are using binoculars, and the outreach is very limited, so you cannot see very far, and it's a huge area. But we also have been using a drone that was installed on top of Humanity-1, when you can see further away, but still it's very limited. And there are civilian aircrafts, 2 civilian aircrafts at the moment that are also surveying the area. But of course, Frontex is the biggest resources. There's so much money also in this, and this must be used to save lives.
Möchtest du noch eine Frage stellen? Hattest du dich gemeldet? Erstmal nicht.
Thank you very much. I'm Yannick Neumann with the Institute for the Law of Peace and Armed Conflict in Bochum. And I would like to especially address what Dr. Singer said with regards to AI and the attributability, because it's of course I would also welcome if maybe the others could elaborate on that a bit, because I share the concern that by using autonomous weapon systems, artificial intelligence to identify targets, etc., there may be the possibility to kind of dodge attributability for maybe wrongful wrongful actions violating international humanitarian law. So the idea of Dr. Singer, or the approach to use treaty interpretation in order to maybe modernize IHL in a way that allows us to still prosecute such crimes, I think it's a good way, but of course there's the concern about consensus, right, with the states who are parties to the treaties. But it made me think of this living instrument doctrine, which we mainly associate with the European Convention on Human Rights. So I would just ask for a little, just for a little bit of your thoughts. Might this be a viable approach? Is there another approach that is possible? So if you could just briefly elaborate on that, I would be grateful.
Okay. Well, concerning firstly the question of AI attributability, as I mentioned before, it depends on what AI functions are you looking at, and on the whole process in the end that is conducted. And finally, well, according to Article 57, well, the whole process you're going through it when you're targeting. I mean, there are targeting guidelines. I think even some older ones are open source available. Well, during this process, there have to be taken a lot of human decisions. And according to my experience and talks I had and statements that have been given by states or military actors and so on, I think, at least for the Western world, there is no government that says they want to conduct any form of the targeting process without any human control. Just out of a practical perspective, it doesn't make any operational sense, because you don't want to have a shooting actor running havoc on your battlefield and shooting your own troops, because some of the bigger Western states have made their experiences with friendly fire, and you don't want that. And therefore there will be always some sort of human control. But going one step further to look at the weapons control, well, there will be are processes in the weapons review process included where there is some sort of testing. So you will have of course, responsibility of the human actor who tested the thing, who says like, yeah, well, it's working, or it's working with 99%, whatever, which brings up a whole different problem up with AI, because AI will never have 100% certainty. AI will always have a certainty, I don't know, depending on the model, on the training data, input, bad data, bias, whatever. When you're lucky, you can get 95%. Take up the decision. Well, the governments have to take up a decision on what probability they want to accept with the outcome. And as the risk, therefore, is always there won't be any, as an additional argument, in my opinion, no reasonable government will use such tools, because it knows there is a risk, like without any control. So this is the first thing. The second thing is the concept that is also, in my experience, also established very harshly in the ROEs, rules of engagement and so on, of the Western militaries, is the rule of commander's responsibility. So if you look at a military operation using an AI function in the targeting process, whatever, really depending on the function, the commander who decides to use this tool for this certain military operation because he has it available will make a decision to use it or not. And also to make the decision like, do I engage the target or not? And therefore you have a very, very clear established human responsibility. And so I don't see the attributability problem at all, because from a practical perspective, it won't happen. But have a look at other states, and have a look at the compliance of other states on IHL. Of course, you will face this problem as like the technology and the fastness, the speed increase and so on is more attractive than obliging to these old crazy rules from the 20th and 19th century, to say it really with a bad remark. So come back to the living instrument doctrine. In my opinion, I think, again, you won't get the exceptions by the governments, because the governments will have a look at an acceptable way to use a modern technology, but also in the conduct of hostilities, as we can see with the UNCCW process. But to give also a last positive connotation, the whole UNCCW process on lethal autonomous weapons led to one thing, that a lot of Western governments stressed again and again that there will be some sort of human control in everything, and that there has to be a very thorough look at the targeting process, at the decision-making process, and to get more clearly. And this is kind of a positive outcome of this process, even if there's no new rule, but it made the governments reconsider, and also like the media attention that came to the whole process, and which is still continuing on killer robots, whatever is used a word for this technology, helps to to keep the pressure high that certain decisions are made, and the Pandora box is not opened.
Hello, good morning. My name is Markus Geisser. I happen to work for the International Committee of the Red Cross. Maybe just I really found that question from our colleague from Diakonia really important, and it would have also been my question, especially in engagement with private industry. And I think from an ICRC perspective, so this is my first comment, I think what is important is that these conversations go beyond bilaterals. There seems to be a tendency to have this conversation, just think of the ICRC, we talk to Facebook, we thought to these various organizations, but of course the states need also to be in the room, yes, because after all, who orders these things, yes, if I think of artificial intelligence, well, it's a state that of course orders it, but of course technicians very often sit in technology companies. Just more of a comment, but of course, please make your point about it. My question now is that I wasn't quite sure whether there was consensus, whether IHL here on the panel applies to non-state armed groups. Yes, I mean, we've got the historical perspective. I think, Dr. Singer, you mentioned the additional protocol number 2. So how does it apply, if at all, to non-state armed groups, which I think is very important for this conversation about technological change, because today, of course, as we sort of all know, it's not only states that use drones. The drones have become the AK-47 of today. It is also non-state armed groups. I just would like to broaden up a little bit the conversation, going beyond the state responsibilities. I've got another question, but I keep that maybe for the end. I'm sure there are many more other questions.
I'd start with a comment on the comment. So I liked what you shared about the responsibility of private companies and also the influence or the role states still play when it comes to that. And I'd like to emphasize on that, because I think for example, when it comes to the removal, I mean, when it comes to content moderation, we already see that a lot is happening. I mean, obviously these laws which are applied for example, content moderation when it comes to Europe, the Digital Services Act, they are not meant for international or non-international armed conflict. That's not their main field of application. However, I think they unfold general effects. And I think these effects also apply, these effects are also unfolding then in the battlefields of the world and lead to an approval of content moderation when it comes to the removal of hate, incitement to violence, also in armed conflicts. And at the same time, we have a lot of discussion also about the silencing of voices, of legitimate voices who are raising concerns regarding possible violations of humanitarian law, for example, in current conflicts. I mean, the Gaza conflict is probably the biggest challenge to content moderation in the history, at least in the younger history of social media platforms. But in particular, when it also comes about evidence and evidence of violations of international humanitarian law. I've mentioned this before, that some of this evidence, videos, pictures are simply removed because they violate the terms and conditions of the platforms, but they're actually necessary for public documentation, also for documentation for possible persecution of such crimes. And I think there are already voluntary, you probably know more about that than I do, there are already voluntary commitments by platforms to simply disable the public appearance of these images and videos, but still save the material and give it to authorities or NGOs working in this field of evidence collection. But this could become mandatory legal obligations, and easily mandatory legal obligations by the European Union or by the United States that such material which is removed because it, for example, depicts violence is not simply removed from the server, but then hand over to entities which try to engage in evidence collection. Maybe you want to add something on?
Well, just to continue on the states make law statement. You have different legal regimes also between the European Union, the national states, and the US. So also depending on the seat of the company and so on, it might get really hard to regulate and enforce certain laws on the companies. But on the other hand, you can see by now by the bigger judgments, for example, by the ICJ on Facebook, on Microsoft and so on, that there are certain handles that can be at least tried. I mean, you will see we will have to test the outcome, and if the outcome is a 300 million fine, someone like Google or Microsoft they barely feel the effect. So there have to be a more, I think, really international agreement on how to treat like really the big tech companies. And let's not forget there are huge tech companies also in Asia, which are totally out of any reach of our Western governments. So this is, in my opinion, also again, very deep question, how to treat such huge companies, because they are not too big to fail, but probably too big to regulate. Also, like the effects that only a few people own these companies, and there's very less really basic control on them, can lead to a very harsh effect in democracies, because if a democracy wants to regulate such a company, the person who owns the company or partly owns the company has a lot of financial background to enact influence, give money to the other parties that don't want to regulate it, and so on. So this is a very big problem out of a judicial perspective, out of a fair government perspective. Coming very quickly to the linked question with the applicability of the IHL to those actors. Of course, those actors are bound by certain basic rules and so on, but you have to consider under what circumstances. So you have to go really to the basic start and say, like, are those actors involved in any sort in this international or non-international armed conflict? Or if you look now to recent international armed conflicts, you will have very complex applicability questions if you consider those companies part of this conflict environment, because then you might have an international armed conflict with a non-international armed conflict component linked to it, depending on the qualification of the company. And if you see, like, the company just does IT, the company just enables data sharing, we are just having satellites in the air, everyone can use them, it is very hard to get this in accordance with the definitions of an organized armed group made by the ICRC in the notion of participation in hostilities guidelines and so on, and also to the existing customary international law. Or if you look at Article 51 with the direct participation in hostilities, that could render the single person eventually a target, but again, I think in these cases it is very important to look at the single use case, at the single company, at the single case that happens, and then decide based on the IHL. But I wouldn't exclude that it's not applicable or so on, but it can be, but it depends.
What a lawyery way of ending this conversation. It depends. I'm looking into the room to see if there's additional questions that you would like to raise. There's one in the back.
I'm not supposed to ask questions, but I'm Josh. I work for Doctors Without Borders in the German section in the communications department. And I found it interesting, it was mentioned about misinformation, and that's a huge topic for us. But also there was a comment made, I believe Erik, you made this, about the fact that you need to be a lawyer to be informed about whether the information that's being put out is actually true or not. And my question is there been advances in AI for the user experience on checking information, especially in the context of international humanitarian law? And that's the question for anybody, I guess.
I mean, that's probably the most difficult topic when it comes to content moderation for the last 1.5 minutes. Okay. First of all, I think I'm bringing bad news. From what how I understand the current scene is that what AI mainly does, particularly the developments when it comes to large language models, is decreasing, not increasing the quality of information. We have so much more bad quality text on the internet right now than we had 2 years ago. And it's a problem for a wide variety of institutions who are trying to collect and improve the quality of information on the internet. I think there is some hope also. Like, AI is very broad. When it comes to, for example, the linking of correct information to questionable posts or statements, I think there is something AI can do. But in the end, it's also a lot about trust, and about trust in institutions, trust in media institutions who are surveying or who publish these kind of information. And I think this kind of trust cannot be ordered. So what I'm trying to say is that I think why it is so difficult for me is that I think there are many at the moment who hope that AI will somehow solve the problem of misinformation and disinformation, and I think that's not the case. AI currently makes the problem bigger, and AI can be a good tool to try to give more background, to try to contextualize information, but in the end, trying to fight the misinformation crisis is to a large extent a crisis about trust. And I think that the technology will not solve the issue of trust, but it is something brought forward by many stakeholders. But I would call this more a techno-solutionist approach, and I think what we need is some kind of societal approaches who are increasing trust in information and in particular stakeholders publishing information, like free and independent media.
Thank you so much. If there's no further questions, then I would say this concludes our session now. It is followed by a lunch break in the cafeteria, and then there will be 3 parallel sessions from 1 o'clock onwards: Unpacking the Climate-Water Nexus in the Kleistsaal, Gated Europe in the Edison Saal, and Hidden Wounds, Mental Health and Psychosocial Support in the Kepler Saal. So I wish all of you an interesting remaining day at this Congress, and I would like to invite you to please join me in thanking our panel for their time and contribution. Thank you.